Balilo. Good morning. You may proceed.
Thank you. Good morning, Your Honors. May it please the Court. My name is Joseph Balero, Jr. I'm here on behalf of the appellant, Mr. Glacken. Mr. Glacken was convicted of first-degree murder with extreme atrocity and cruelty on January 25th, 1999. It has been some time. This is his first appeal. He had some difficulty locating representation, and when he was successful in acquiring me, I moved for a stay, and the court graciously allowed it so that I could appear in the trial court on a motion for the trial. This case involves the death of a Frank Sullivan on June 14, 1996. The defendant, Mr. Glacken, was charged with murder in the first as a consequence of that death. I have briefed two issues for your consideration. I would like to address the first issue, and barring questions from the court, obviously I would submit the second issue on the brief. This was an unusual case in the sense that the defense to the murder one indictment was clearly and unequivocally manslaughter. Defense counsel stood in front of the jury in opening statement and assured them that his client would not be going home, that in fact he should be found guilty, but guilty of manslaughter and not guilty of murder in the first degree under either theory, deliberate premeditation or extreme atrocity and cruelty. Defense counsel as well, in closing, repeated that assertion that his client should not go home, but should be found guilty of manslaughter. The issue presented to you is one that involves the instructions to the jury regarding these unusual circumstances, where we have a case where a defendant stands in front of the jury and says, I am guilty of something, but I am not guilty of the major crime. The proposition that we are asking you to consider in vacating the judgment, overturning the jury's decision in this case, is that in cases where a defendant stands and proposes that he is guilty of something less, there is no realistic probability that a jury is going to find him not guilty. Now, this is not to suggest that I'm asking the court to change any of the burdens or tenets of constitutional law, protections afforded the defendant. But we have a situation where we need to provide the jury with the highest level of clarity as possible on the law and how they should treat the evidence. The complaint in this case is that that was not done. The judge in the trial court followed our standard model instructions. He instructed on burden of proof. He instructed on presumption of innocence. He instructed on self-defense, which I would submit to you is part and parcel of the claim here that the jury was confused and misled by the instruction, because self-defense was not a defense in this case. It was manslaughter. And realistically, the evidence only fit one theory of manslaughter, which was excessive force in self-defense.
But so you have to get to self-defense in order to get to excessive force in self-defense,
I
right?
understand that perfectly, and I'm not suggesting. It's been a struggle all along to try and clarify in my mind and articulate this as intelligently as possible. What I'm suggesting, Your Honor, is that it's not so much that there was error in the words of the instruction given to the jury.
Did the judge follow the model instruction for self-defense and excessive use of force in self-defense?
I would suggest yes. He instructed essentially that if you find the Commonwealth has proven the defendant unlawfully killed the deceased using excessive force in self-defense, you must find the defendant not guilty of murder, and you should return a verdict of guilty of manslaughter. The complaint presented to you, and the reason we suggest that the matter should be vacated or overturned, is that there should have been more said to the jury. And I'm certainly not a sophisticated jurist.
Is your issue, and it may not be, I mean, I know that it focuses on that particular section of the instructions, but is your sort of more general issue that the step down, if you will, from murder to second-degree murder and then to manslaughter in this, under the model instructions, or in this case, or both, is confusing? Is that part of what you're
Well,
saying?
I think in this case, it definitely was confusing. And by way of example, and certainly understand I'm not someone that can actually draw instructions, but by way of example, I think that the court definitely should have made it clear to the jury that in this case, there is an issue of voluntary manslaughter that has been proposed by the defendant. He is saying, I am not guilty of first-degree murder. I am guilty of voluntary manslaughter. If you consider from any of the evidence that you feel is credible or true, that the defense of voluntary manslaughter to murder one has been supported by the record beyond a reasonable doubt, then you are to find voluntary manslaughter. You're not to reject the defense of voluntary manslaughter merely because the Commonwealth didn't offer it. The instruction that was given led the jury to believe that if the Commonwealth did not offer voluntary manslaughter because it was their burden, that they were not to consider it. Any other instruction given on impairment, on self-defense, on excessive force and self-defense, led the jury to believe that it was to be applied to the second and third prong of murder one or the second prong, malice, of murder two. But because the Commonwealth didn't offer, it was their burden because they didn't offer it, reject it.
Did the judge say, as part of the instructions, that in this case there is evidence of self-defense? That
he did say self-defense has, there is evidence of self-defense in the case, so I'm going to instruct you on self-defense.
so, and then he had to say that the Commonwealth has to prove that the
Which is accurate. The issue I'm taking with the trial court's instruction is that he didn't provide the highest level of clarity possible to the jury in the deliberations by explaining to them that the defense that's proposed is voluntary manslaughter or manslaughter, and you're not to reject that simply because the Commonwealth didn't offer it or the defense did offer it.
But didn't
If
say
from any and all the evidence it's supported.
Did the defense
I'm sorry.
request a specific instruction on this point from the judge?
No, unfortunately, he did not.
So he should have done it sua sponte.
I would suggest yes, because I believe it would be the duty of the court to make sure that there is this highest level of clarity as possible in the jury's mind when they deliberate. There is a very real probability, a very, very high likelihood that this jury went back and simply said, are we going to consider manslaughter? Well, no, the Commonwealth has the burden of proving that. They didn't offer it throughout their whole closing statement. They said it was murder one.
But you
It's
say
murder
this is
one.
not an Acevedo problem, in your view.
No, and I do take issue with the Commonwealth's directing the court to Acevedo. I'm not suggesting that it is a pure Acevedo problem. It is an issue of a lack of clarity in the instruction by the trial court in a capital murder case, in a circumstance, a very unusual circumstance, where the defendant stands up and says, don't find me not guilty. Find me guilty, but don't find me guilty of murder one.
And
I'm
by the
guilty
way,
of manslaughter.
our facts are the victim was stabbed 30 times.
Correct. Actually, there were 42, not stab wounds, but there were 42 indications of a knife. 12 of them were on cuts on a shirt. 30 were penetrated wounds. And I would submit to you that it's unlikely in this scenario that a jury would consider provocation in the form of sudden combat and or heat of passion. The facts most likely, I think realistically, would have either fit excessive force and self-defense or extreme atrocity and cruelty.
No, but the provocation, though, well, I mean...
Mr. Bolero?
It's a struggle. I've had discussions with defense counsel in conference, and once they get over the glaze of horror that a defense counsel stood up and said, find him guilty of manslaughter, we get into very sophisticated and intellectual discussions about how you would instruct. But
Mr. Bolero?
Yes.
I take it that the judge began this whole manslaughter self-defense instruction by saying that there has been some evidence of self-defense, and the Commonwealth has to disprove self-defense.
There's no question
No,
he
no,
did do that.
okay. So then the judge moved on and gave the language, I take it, that you say is the problem. And he said that the Commonwealth can overcome this by proving that the defendant, it can avoid a not guilty verdict on the issue of self-defense if the Commonwealth proves beyond a reasonable doubt that the defendant used excessive force in self-defense.
Correct.
And I think, let me begin the discussion here. I take it in isolation, what you're saying is, that instruction doesn't make any sense in this case because the Commonwealth never took the position that this was a self-defense case, right?
Correct.
And so why should the jury was probably misled by the idea that the Commonwealth has to prove beyond a reasonable doubt that the defendant used excessive force. They didn't take that position.
Correct.
But wasn't the Commonwealth forced into that position by the self-defense issue? In other words, that wouldn't even come up unless the defendant had, unless the Commonwealth had failed to prove that the defendant had not acted in self-defense.
And I do agree with you, Your Honor. The problem I have is that the trial court didn't go far enough, given the unusual circumstances of the case.
But how do you describe the Commonwealth's burden of excessive force in the negative, which is what we usually have to do? Isn't the negative introduced by the concept of self-defense?
And therein lies the problem, and I've struggled with trying to design an instruction. Should Your Honors have asked me what kind of instruction would you suggest, I don't think I'm sophisticated enough intellectually as a jurist to try and do that. But my suggestion is to Your Honors that in these circumstances, it needs to be made clear to the jury that they may not reject the defense theory, of which he's got a right to propose, simply because the Commonwealth didn't offer it or has the burden to prove it. And I'd submit to Your Honors that an accurate statement would be that if you, the jury, find from any and all of the evidence you feel is credible or true, that it has been established at this trial beyond a reasonable doubt that the defendant committed manslaughter, excessive force and self-defense, then you are to return a verdict of manslaughter. I'm not suggesting we leave out the burden part. I mean, that needs to go in, but this is not a case where the defendant said, I'm not guilty completely. It's a case where he stood up and said, I'm guilty. I'm just not guilty of first-degree murder. So he's entitled to have his defense presented to the jury. The way this instruction was given created a very real risk that the jury completely disregarded that manslaughter defense because it was not offered by the Commonwealth, because the Commonwealth had the burden to prove it. And because the Commonwealth got up and said, we're not offering manslaughter. We're combating manslaughter. We're saying, no, don't do it. You know, we want murder one. And the defendant got up and said, no, it was manslaughter. It wasn't murder one. So the instruction on the whole took that, created a real risk of taking that defense to first-degree murder, manslaughter, away from the jury's consideration. And it needed to be clarified more. And there needed to be an enhancement to get to that highest level of clarity possible in a capital murder case, to allow the jury to consider all the evidence in the case, all the credible evidence in the case. That's the issue I have for your consideration, other than the second issue that we presented, which I'll rest on the brief for. And if Your Honors have no further questions, I hopefully have presented with some clarity, the highest amount of clarity as possible.
Thank you, Mr. Villiers. Ms. Eisenhower?
May it please the Court, Rachel Eisenhower for the Commonwealth.
The judge followed the model instructions in all respects.
I believe so, Your Honor. He did follow the model instructions, and
No requests for any additional instruction by defense counsel along the lines of what has just been argued.
not to my recollection, Your Honor, nor did he protest.
The issue of manslaughter was fully argued to the jury by his counsel.
To my knowledge, Your Honor, yes, it was.
Okay.
And I think that there is no Acevedo error in this case. I briefed it out of an abundance of caution in case the court wanted to look at it under that framework. I think that the judge's instruction, even read in isolation, is correct in context.
This model instructions on manslaughter in this regard have been given now for about 7 years, and no one has ever claimed an Acevedo error. And Mr. Bolero says he's not claiming one today.
I don't think that the instruction shifts the burden of proof in any way, even under the scenario where the defendant is seeking a verdict of manslaughter rather than an acquittal. I think that at best, what the instruction says is that the Commonwealth has the burden of proving, 1, an unlawful killing, and 2, excessive force in self-defense.
That's precisely what the judge said.
It is.
Commonwealth has proven, you have to find a Commonwealth has proven that the defendant unlawfully killed the deceased using excessive force.
It's true. And I read that as proving 2 elements. 1, unlawfulness, and 2, excessive force. I think that the
Yes.
words self-defense are in there describing excessive force for clarity, not saying the Commonwealth has
Well,
the burden.
he already said, as I understand the instructions, that the killing has to be unlawful, and the killing is not unlawful if it's done in self-defense. So this is a refinement now of the theory of self-defense, right?
Exactly. Exactly, Your Honor. On the second issue, I believe that requiring the judge to inquire whether the defendant has waived his right to testify would be tantamount to requiring a colloquy, because even one question would indicate to the defendant that what he was doing might be disapproved of by the judge. If the court has no further questions, then the Commonwealth rests on its brief.
Thank you, Ms. Eisenhower.
Thank you.